All right, here we go. Welcome to the Hearse Chaser podcast show. Our topic today is the dirt on deeds. What you're really signing. So a lot of times people call my office and say, I need a deed. And I say, great, what kind of deed? I don't know. I just need a deed. We're going to break down deeds in our next podcast on the dirt on deeds. Welcome back to the Hearse Chaser podcast show.
You're listening to the Hearse Chaser podcast show. Here's your host, Stephen McClellan.
Welcome back. So deeds are a topic that come up all the time in our practice. I don't know how many we do. I know we've probably done thousands of deeds. And even the term, well, what is a deed? Let's talk about that before we talk about anything else. First, a deed is typically a legal description, basically a shape of some sort. In most cases, it's like a square, a lot. It might be a lot to hundreds of acres. It might be a whole section, 600, I think that's 640 acres. But the idea is that the deed is a legal description. A lot of people ask me this next question. Okay, we bought the land about 20 years ago, and we just built a house on it 2 years ago. But we never got a deed for the house. Well, the house is on the land, and that's how it works. Okay, you don't get a new deed just because you built something on the land. So if you were wondering about that, no, it covers the things that you are attached to. Now, if something is an RV, a mobile home that is not attached to the land, it might not include that. But generally speaking, people reach out to us because they have a home, they have a rental home, they have land, they have a lot. Even timeshares typically are on some type of a deed. So those are all the different types of interest that could be on a deed. Even mineral rights can be on a deed. So the question is, what are the most common types of deeds? So first type of deeds, if you've bought a home, you probably received a warranty deed. That means the sellers are guaranteeing that they had good title. So if you have any issues, you can go back to them and sue them, okay? And that's what you want. That's very different than a quitclaim deed, okay? Not a quick claim deed. It's not like a fast deed, okay? Quit here is Q-U-I-T. A quitclaim deed just says, whatever interest I have in this land, I am giving to you. So in essence, I could quitclaim the lot or lots that the White House sits on, and I could transfer that to Mickey Mouse. Well, first, I have no interest in that property, so me transferring it to Mickey Mouse, he gets nothing, okay? Oftentimes, these type of deeds are used when we're trying to just get rid of an interested party. So, for example, you have 3 kids on a deed, and we want the youngest to say, I have no interest in it. They could quitclaim their interest to the other 2 kiddos and say, look, I have no interest in that deed. So that is a quitclaim deed. Now, when it comes to estate planning, sometimes we use those. Sometimes we use what are called beneficiary deeds. Or you may have heard the term transfer on death deed. I think that's what Kansas uses. Some other states have a term called ladybird deed. The idea is that I own the property. When I die, it goes somewhere. And we haven't had these deeds forever in my state. I believe 2006 was when beneficiary deeds occurred. Now, why they're nice is because I can change my mind. So let's say my beneficiary deed says, when I die, I want my property to go to my oldest kid. And that oldest kid marries someone who's awful, rotten, stinking, and disowns me, okay? I can revoke that beneficiary deed and say, now it goes to my other 2 kids. So that's what's nice about beneficiary deeds. one of the things to know when it comes to deeds is how a marital status affects a deed. So in our state, for example, if I go out and buy a house and it's just in my name, okay, the deed says Stephen McClelland, Hearse Chaser, you own the property. Technically, my wife has an interest in that property. So if I decided to sell that to a third party, that title company, in our state, it's typically title companies that handle that transaction from buyer to seller or seller to buyer. And they're going to say, oh, Mr. McClelland, you have a Miss Hearse Chaser. I say, I do. She's the one actually came up with this name. And they say, okay, thanks for that fact. Well, we're going to need her to sign off on this deed. So in our state, if you're married, that wife has an interest in it. And if it's our residence, she would have a homestead right in that property. If it were additional land, she'd have like a dower interest in it. So there are so many implications of what I just said. So when you receive property or sell property, there's this idea of what is clear title. Okay? And the best way to describe this is how they teach law students in law school. So they refer to land property as a bundle of sticks. I don't have a bundle of sticks. I have in my hand 2 pens, right? And the idea is that if I own this land without restriction, it's mine, I can do whatever I want to. It's considered fee simple absolute. Absolute, I have full control over this, okay? The moment I start doing a deed and putting conditions or restrictions, then I'm giving these different sticks in different ways. So think of it this way. Perhaps I have 2 sticks and I give one to my daughter and say, daughter, you have the right to have this property for as long as you live, but when you die, the other remaining sticks go to a charity. Okay? You can do that. You certainly can do that when it relates to real property. Now, what often happens that I don't like, okay, and title companies might say the same, is this language of a first right of refusal, okay? Here's the problem. So often in my state, and this is true about most states, land is very, very personal. It could be personal in the sense that it has been in the family for 100 or 200 years, and they have the president, like Andrew Jackson or something, signed the deed that they received. And so they want to keep that property in the family. I completely understand that. So they will often say something like, before this property is sold, it has to have a first right of refusal to these 6 people or their heirs. So it almost makes the property impossible to sell because we've got to satisfy 6 people in order to sell this property. And the more, if it says heirs, it could be a lot of people. And the trouble is, I've had many situations where you just couldn't get that person to respond. Maybe they had a falling out with the family. Maybe they were incapacitated. Maybe they're just being jerks and they won't sign off on it. There can be any number of reasons. And now the property interest is just kind of stuck out there. So long story short, you got to be very careful what you put in these deeds because one phrase can just mess up an entire sale in the future. So oftentimes, the question is, I have this land and I have this family and I'm concerned about the land going into the name of the entire family because there's people that I don't want to get the land, okay? So it's important to think in terms of how can I set my family up for success. For example, if I have 100 acres and I'm looking at my kids and like, my kids don't live here, they have no attachment to this land, or perhaps this 100 acres is just It's just not, it makes more sense to sell it because my kids, grandkids, they just want cash. Okay. So if you had a will and just said divide everything to my 3 kids, or a beneficiary deed that transferred the property to all 3 kids, you're going to have a problem with, well, how do you sell that property? Okay. If you put it in a will, the will says, upon my demise, the property must be sold, the proceeds liquidated. I caution you on that because your family's stuck in probate, and that's going to be expensive. It could be $10,000 to $20,000, $10,000 to $12,000 on average in probate, and take over a year to resolve. And if you live in a state like we do that says, well, an attorney's entitled to 3%, you got $1 million piece of property, that's $30,000. And maybe you're fine with that. If you are, fine, but I don't like that. You're stuck in probate, not fun. The better thing here is a trust. Okay, a trust is, instead of the property going directly to a beneficiary, to the 3 kids, it's going into a trust. And the trust can say, I want my youngest kid to sell the property. Most people don't say that. They say they want the oldest kid to do that, or whoever. The idea is that if property goes into a trust, then I can elect the one person responsible for that to sell. What's great about that is it's private. It doesn't get filed with the court, the trust that is. I don't have to deal with probate lawyers. That's fantastic. I don't have to deal with a probate judge. That's fantastic. So I can speed up the process to sell it. And importantly, in my case, got 3 kids. Technically, I have to get all 3 kids, and if they're married, their spouses would have to sign off on that. Well, it only takes one out of those 6 potential people to cause a ruckus, right? I don't know if that's the right word, but if I have a son-in-law who is a jerk, treats my daughter bad, he's probably not going to sign off on the deed. It's going to cause problems. Emotional manipulation, they just got extra credits to use against the whole family, okay, for something they're not happy with. And it gets more complicated, too, if the property's left to my 3 kids, but one of them died. And now that interest goes on to grandkids who may be minors. And in order to sell that, I'm going to have to get the court to approve that.
Thank you for tuning in to the Hearse Chaser podcast show. Our mission is to be your first choice for last wishes. Want to dive deeper? Join us over at the Hearse Chaser Academy, where we've created 8 on-demand courses for each stage of life. From young adulthood to retirement, navigating separation or blended families, and everything in between, we help you plan for the future, no matter where you're at. Now stay with us as the ride continues on the Hearse Chaser podcast show.
So here's how it works. A 16-year-old, a 15-year-old cannot sign a contract to sell a home. So the title company will say, I understand that this went to grandkids and they're minors. We need to get a court to approve this sell. So that just slows things down. I don't have to worry about any of that. If I dump it into a trust and I say my youngest kid is trustee, they can sell it, they can sell it. I don't have to worry about the minors. I don't have to worry about courts. It makes it a lot smoother. And the bigger the asset, the smoother you want it to be. Because if you have a $500 million piece of property, you really want that transaction to go smooth. You don't want to be stuck in probate, and you don't want people fighting over it. At the end of the day, I'm a huge, huge fan of clarity, simplicity, get it done. If you put a bunch of restrictions on it, if you try to say, well, I'll just let them decide, it's kicking the can down the road. It is better, I think, to have the family be mad at you than be mad at the survivors, okay? Because they always go back, well, that was Dad's idea. Dad, that was a dumb idea Dad did. Better than them arguing against my youngest daughter that she sold it. Well, Dad told me to. You're mad, be mad at him. They can be mad at me all they want. I try. That's the one thing I try every day is y'all want to be mad at someone, be mad at Dad. Just don't be mad at each other, right? Because, if you know kids, they will always find a reason to be kind of upset. This is important. Joint tenancy versus tenants in common. So things I'm telling you here are kind of Arkansas-based, but if I leave property to my 3 daughters, that's all it says, daughter A, B, C, and I die, assuming my wife and I do that, then it's in the default in my state is tenants in common, which means that if my oldest dies, her share goes potentially to her spouse and kids, okay? And so then the interest gets more and more diluted. And so I really want to caution that things are fine when it's grandma and grandpa's name or mom and dad's name. It gets more convoluted the longer property goes on. And I've had situations where maybe 10, 15, 20 people have had an interest in a property. It's undivided. It's basically unusable. Like nobody has full ownership. And you can't sell it because there's no way you can get all the heirs to agree. And so someone in the family is paying the taxes every year to make sure that it doesn't get foreclosed on by the state. It's a real, real big mess. So tenants in common lends itself to this continual dilution of the interest. Very different than tenants, joint tenants with rights of survivorship. If I leave it to my 3 kids, rights of survivorship, whoever survives gets it all. And that can kind of eliminate the dilution of the interest forever and ever. Okay. A couple things about deeds is if you have 100 acres and you sold 10, the highway department came in. That legal description can be very, very complicated. What I mean by that is that shape is sort of getting smaller and twisted a little bit. Maybe you bought some from somebody else. And you got to get that legal description right. And that's very important, no matter what deed you do. Here is probably another reason you want your lawyer younger than you, okay? Because a lot of times the legal descriptions or issues don't come out until years after someone is gone, okay? And that attorney, if they're still alive, they can sign a scrivener's error or an affidavit saying, oh yeah, the legal description was wrong, and that can kind of clean up that title. Clear title is the name of the game here. And this has happened with my partner. He practiced 30 years before me. Did he make some mistakes on deeds? Yeah, everybody makes some mistakes on the deed. It could be a misspelling of a word. It could be just something got transposed. And if that happens, like in his case, I've talked to the title companies. I said, you guys understand that you're asking me to sign a scrivener affidavit for him before I even went to law school. I'll sign saying it was a mistake based on the file or what was presented. It was transposed, but you understand I wasn't an attorney there, and technically it's not even my liability, right? It was him that did the work. So that's very, very important, because if you get these legal descriptions wrong, then you got a whole court issue to go to court to get a deed modified and corrected. So that's why it's important that you work with somebody, not only who gets it right, but will question you, are you sure this is right? Sometimes if you're not sure, you talk to a title company. So a title company, they're the ones who will say, yeah, this is the legal description. Here's where it's bought and sold. So a lot of times, especially when I talk to farmers, I know farmers know exactly how many acres they have, but they don't know the meets and bounds and the degrees and all that. They don't know that. Nobody does. It's way too complicated. And I say, look, I would feel much more comfortable if we had a title company. In my experience, based on the story of this deed, and you've sold part of it, I just feel more, I feel better if we had a title company, say. And how much is it? It's like $150, $250. That's nothing in the whole grand scheme of fixing an error on the back end. And it's not hard to convince them you're doing estate planning because you want to make things go as smooth as possible. And I think they recognize that. Let's talk about deeds in the context of nursing home asset protection here on the very end. You got to be careful because there's a 5-year look-back period. 5 years. So you can't give all your property away on a Friday and Monday say, I have no assets. It doesn't work that way. You can't do that. So you also have to be cautious because if you give that property, you quitclaim it to the kids and it's theirs. Okay, it's out of your control. You have no more control. You've given up all your rights, and if they get sued or file for bankruptcy, now your home is commingled with them. That's why it's good to talk to an estate planning elder law attorney, and instead of giving it outright to the kids, we can put it in a special trust so I don't have to worry about those potential concerns. Okay, deeds are recorded. I don't know if you know this or not, but there's a grantor index and a grantee index. Grantors give away property and grantees receive property. The best way, whenever I have anybody new in my firm, I always ask them, okay, you know the story of Adam and Eve? Yeah. Were Adam and Eve grantors or were they grantees? They think about it, and they say they were the grantees. They received the Garden of Eden, okay? In other words, you know that everybody on earth begins as a grantee. They receive something first, okay? Oh, that makes sense. So if you need a copy of a deed, you can call the real estate clerk. That is their job, to file all these deeds. They're public record. You can call the assessor, say, my name is Stephen McClelland. I gave away property in 1985. So they'll look at the grantor index of 1985, my name, find the deed. If I receive property in 85, they'll look at the grantee index. So a lot of times, if you're trying to find the deed, start with the assessor. The assessor typically will have a book and page number. Then you can go to the real estate clerk to get the deeds. Yes, these are totally different people. The assessor, all they care about is taxes. Okay? The clerk, they file the deeds. So if you bring the assessor's paperwork to me and say, oh, here's the legal description on the assessor, no, it's not right. I need the legal description from the actual deed. And a lot of my clients are 65 and older, and they say, look, I paid off my home, never got a new deed. Here's how that works. It's not that you get a new deed. When you initially received that property, they gave you a deed in your name. And then they filed a mortgage on top of it, typically like a 16, 20-page document saying you owe this money. When you finish paying it, the mortgage company will file what's called a release of that mortgage, and that mortgage goes away. So if you say, I never got any paperwork on that, then you can call the real estate clerk and say, hey, in 2012, I paid off my debt. Can you look for a release of mortgage? So you can go look at that, and that would be public record. Sometimes they don't do that, so it's probably a good idea to check into that. All that to say is I've spent over 20 minutes talking about deeds, and it's more complicated than that. It's important to talk to an attorney and ask, tell them what your goals are. What are you trying to accomplish with the deed that you need drawn up? And the attorney can tell you the pros and cons of things and how to set not only you up for success, but your kids as well. I simply don't buy that it's just easy. It's a simple deed. Well, I want to make sure you understand you really want to give all of this property to your kids, or maybe a beneficiary deed's better. So different deeds for different purposes. So the dirt on deeds is it can get really dirty. It can get really, really messy. But it's important to understand what you really are signing at the end of the day. Because in many cases, that deed is one of the biggest assets that you own, or if not, can be very sentimental and can have a lot of conflict potentially with family if you're giving it to one person and not. So that's the dirt on the deeds. Thanks for joining the Hearse Chaser podcast show. Hope you have a great rest of your day.
Hey, thanks for listening to the Hearse Chaser podcast show. Please remember, you can't outrun a hearse, but you can leave your family with a smooth ride.